Welcome to our discussion today, and the topic of our discussion is the place of public international law in South Africa's legal system. We ask ourselves the question whether international law has any place in South Africa's legal system, and that question is answered in section 232 of the Constitution of South Africa of 1996. Section 232 under the subheading Customary International Law reads, Customary international law is law in the Republic unless it is inconsistent with the Constitution or with an Act of Parliament. The next section, which is section 233, then goes on to say, when interpreting any legislation, every court must prefer any reasonable interpretation of the legislation that is consistent with international law over any alternative interpretation that is inconsistent with international law. Another very relevant section of the South African Constitution is section 39, which enjoins the courts to develop the common law and customary law consistently with international law, enjoining the courts to consider foreign law as well as international law in the adjudication of legal disputes and the resolving of legal questions in terms of South African law. So without speculating and insinuating into too many things, customary international law as well as conventions to which South Africa is a signatory are part and parcel of South Africa's legal system. They are not external, they are not peripheral, but they are integral to the system itself. A very critical and very important question as a point of departure regards what we mean by public international law. It is very, very important for us to understand what we mean by public international law. In a very simplified maybe expression, one would say that public international law actually refers to the rules and principles that guide and govern and regulate the relations between sovereign states, as well as the relations between sovereign states and international organizations which constitute sovereign states, which are constituted by the various sovereign states. For instance, we may have one state, a sovereign state, let's call it A, and then another state, which for the purpose of this discussion, we will call B. Now we are saying, suppose these two states, A and B, share contiguous territory, or even if they don't happen to share any contiguous territory, they may be conducting trade and other interaction, maybe sharing diplomatic relations and so on. We are saying that the rules and the principles that guide the relationships between those two states, or between the numerous states that make up the world states are concerned. So the relationships between them are guided by public international law principles. We have also said that there is a reference to international organizations. We have in mind the United Nations Organization, or the African Union, or the SADC, or many other, international organizations which are constituted by various states coming together on a voluntary and consensual basis to create an international organization. So you find that the states and international organizations happen to be the subjects of international law, whilst individuals have largely been excluded from, the rights to enjoy, legal subjectivity in international law. In other words, it has always been assumed and taken that individuals do not have, do not enjoy rights in international law except as citizens of sovereign states. That then would imply that the rights of individuals in international law are not exactly the rights of individuals as such, but they are rights of states to the extent that each state, or each sovereign state has that right to the protection of the welfare of its citizens. So individuals have been excluded, but although it will appear in recent years that the exclusion of individuals from legal subjectivity in international law has actually remained a very controversial and contested area, because international law has tended in recent years to pay much attention to the welfare and interests of individuals. So their exclusion is not something that is as clear as it used to be. Until the development of a modern sovereign state, international law was unknown. You will recall that in Europe and elsewhere, particularly in Europe, because Europe seems to lie at the center of the development of these international law principles and doctrine. The states, as we know the states today, were unknown. It was mostly the authority of kings and feudal lords, people who were maybe not even empowered or competent to run states, if one would say, taking from the fact that there was no separation between the authority of the person and the institutions of the state. So you find that the state as we know it today was unknown at that time. It was mostly authority of powerful individuals who could be feudal lords, warlords, and so on and so forth. And the rest of the people lived maybe as serfs, or under their feudal lords, to the extent that the powerful state, sophisticated as it is, with the organized structure that we see of modern states, was unknown. So as a result, you find that there was not much talk about international law, since there was no relationship between the sovereigns, if one could put it that way. But sometime around 1400 AD, that's about 600 years ago, the world saw the emergence of these modern states, organized in such a structure that they had demarcated territory, having permanent populations, and able to maintain diplomatic relations with one another. So with the emergence of the modern state, you find that states begin to constitute themselves into leagues. They begin to relate with one another on the formality of them being states, rather than as representatives of the powerful individuals that constitute them. So with the emergence of the state, then comes the issue of the international relations and international law, the development of rules regarding how these different states are going to be relating with one another within the context of the new configuration of political entities. Consolidated then by the Treaty of Westphalia, where the modern concept of sovereignty was fully developed. You find that from that time, states begin to relate as on the basis of international organizations, having mutual respect for one another, and having set up those rules, as we have already alluded to the fact. So that's how the concept of international law developed, is whereby you find there's a separation between individuals and the state that constituted them. So from around 1648, with the Treaty of Westphalia, we then begin to see that development until the outbreak of the French Revolution in 1789, and the confusion that ensued in France, leading to the emergence of Napoleon Bonaparte as a very aggressive warrior, ravaging the rest of Europe, and his influence being felt all over, right until Metternich of Austria begins to try and bring order by coordinating international relations through his Congress system, and the Congress of Vienna around 1815. All those were attempts now to organize states, to avoid further conflict in the future, and to try and map out strategies about how states can relate with one another without really upsetting global or international peace. So 1815 and the Congress system, we see the attempt now to organize the states, but it doesn't last long. Once again, states retreat they retreat behind their frontiers, until again around 1870, when Otto von Bismarck is the Chancellor, the Iron Chancellor of Germany. You find that he begins some attempts again to reorganize states, when he forms leagues with states such as the Russians and the Austrians, the Drey-Kaiser Bond. And then we have the emergence of the Triple Entente and the Triple Alliance. What about in 1884-85, when it seems like European countries are clashing in Africa? They then convene a Berlin West Africa Conference, where they discuss how to parcel out the African continent among themselves. So all those are steps towards building up and the establishment of solid international rules that would regulate the relations of the states. And then with the collapse again, or rather with the outbreak of the First World War, and the conflict that ensued between 1914 and 1918, the statesmen of the time, that is the European states and Americans, of course, realized how dangerous it was for the world not to have solid rules on the international relations. So we then have Woodrow Wilson, the then American president, drawing his 14 points, and then proposing as his last point that there should be the formation of a League of Nations, which of course was eventually established in 1919 alongside the International Labour Organization. But regrettably, the United States of America, even though its president was the author of the league, the US did not join the league. So again, in 1939, the outbreak of the Second World War, partly instigated by the aggressive policies of Benito Mussolini and Adolf Hitler, leads to another world crisis. And then eventually by 1948, when that war ended, we see the formation of the United Nations Organization, and we have the creation of other international institutions such as these Bretton Woods institutions of the International Monetary Fund, as well as the World Bank. And in 1948, of course, we have got the United Nations, not the United Nations, the Universal Declaration of Human Rights, of course, which is preceded around 1948 by the Nuremberg trials, attempting to try the Germans involved in what was called war crimes and all other human rights violations. Even around 1952, there we have the organization, what you call the conclusion of the Genocide Convention, and there are many other international conventions that are established as a result of that. So one would say the international community has been reorganized in line with these rules from around 1940, rather from way back then. We were traced from 1648 right up to the present day. International rules have been set to guide how nations and states should actually relate in respect of one another. One thing that every student of law finds a bit striking about the nature of public international law is how it differs from all other branches of law, especially if you're coming from a background where you've read your private law, your constitutional law, and so on and so forth. You'll find that international law is a little different in terms of how it's structured and as well as how it operates. For instance, let's look at some of the differences between public international law and your municipal law, because you find that this is where the distinction is. This distinction speaks to the nature of public international law in the context of how it is very unique and just different from the other. Now, by way of comparison, you find that in international law, there is no legislature. You will notice that in domestic or municipal law, the laws are made by the legislature or the parliament. But at international law, there is no such legislature. So law is made on the basis of the consensus between the states that are involved or among the states that are involved. For instance, when state A signs a treaty with state B, these states are bound in terms of consensus on what they've agreed on. Besides the consensus, there is no authority that would impose any binding laws on them. So the consensual nature of public international laws flows from the fact that there is no legislature, and again it is justified by the grounds that it is between equals. Remember, these are two equal sovereigns. So on the basis of the sovereign principle of sovereign equality of nations, you find that it is only on the basis of consensus that states can really come together and establish a law. So, and again, there is no supranational court that is able to serve as the final court and impose obligations on everybody. So even the court system itself is actually flowing from that consensual nature of the law. So there is no precedent system, and each state provides a judge where there is a dispute involving that state. So you find that in the absence of a precedent system and the fact that states are able to send their own judges, it violates the principles of natural justice. For instance, this nemo judex in causa sua principle, where we are saying no one should be a judge in a cause that is their own. In other words, if one is a subject of the legal dispute, then naturally they should not be involved in the resolution of that dispute other than by way of presenting their own case and then allowing a neutral umpire or arbiter to help them resolve the issues. And then again, because of the principle of sovereign equality of nations and the absence of an executive organ which is presiding and overriding over everybody, you find that sometimes the enforcement of the decisions or legal decisions of these international tribunals and consensual courts such as the International Court of Justice and so on, it sometimes becomes difficult even if a judgment has been made. If one state which is a subject of the judgment refuses to observe the judgment, execution becomes almost impossible, other than maybe resorting to sanctions which are sometimes and often very weak. You find that the decisions of the international tribunals are very, very difficult to carry out and enforce. Of course, we have to underscore the fact that the it is only sovereigns or sovereign states who are subjects, who are legal subjects, who are bearers of rights and obligations in international law, and not individuals. Individuals are subject to the laws of the states or the municipal authorities that they happen to be resident in. So international law is only concerned with the states and the relations between states, without much attention to the individuals and their welfare. The subject of the sources or the authorities that are often referred to or resorted to as one tries to establish what the position is in terms of international law, they are covered in a separate video. Safe to say that maybe Article 38 of the statute of the ICJ, that is the International Court of Justice, is very, very defining and very significant in terms of highlighting what the sources of international law are. It's that Article 38 speaks to both the subjective and the objective legs of the sources of international law and what it is, because we have an objective element and a subjective element, namely what we call the usus as well as the opinio juris principles. But as I have already said, I think you should refer to our video on the sources of international law, particularly in the context of the ICJ statute. But maybe just to highlight a few things, you find that according to Article 38, we are told that the sources of international law include treaties, custom, general principles of law observed by civilized states, as well as the judicial decisions of tribunals. But of course, taking into account that in the absence of the stare decisis or the precedent principle, you find that the influence of previous judicial decisions of the international law is persuasive rather than authoritative. But maybe for the time being, let's just leave it there and ask you to refer to a video that looks at it in specific detail. It was highlighted at the beginning of this video that South Africa does consider international law as part and parcel of its own legal system. Now, this brings us to the issue of ways of incorporating international law into domestic law so that it forms and constitutes part of the domestic law. There are two principles here that are often applied. Some states apply what is called a monist principle, while others apply what is called a dualist principle. Now, in terms of a monist system, it is taken that national law or municipal law and international law are one legal system, and under such circumstances it becomes almost unnecessary to incorporate international law into the municipal system, because it is taken for granted that the international law is already part of that municipal legal system. So a country which applies the monist system actually assumes that the law, that is the international law, public international law, or the conventions, once a state ratifies a convention, therefore there is no need for any internal statutes to incorporate that law within the domestic system. So that's what the monist system does. But the dualist system, on the other hand, assumes that in municipal law, that is national law, and international law are two different and separate systems, to the effect that it becomes necessary to incorporate international law into municipal law, either by way of a statute or an express statute that enables the courts, that is the municipal courts, to be able to defer to the principles of international law. So on the basis of those principles, that is monism and dualism, I would like you to think deeply about South Africa's legal system, whether it is a monist system or it is a dualist system. Again, I discussed this issue in another video. If you are really interested in that, then you may always follow up on the video titled Monism and Dualism within the context of South Africa's legal system. Monism and dualism within South Africa's legal system. So you may defer to that if you really want to find out more about South Africa's method of incorporating an international law into the domestic system of law. Hopefully, you have found this discussion enlightening. We have traversed quite a lot. We cannot really cover much ground on one video, especially when it comes to international law. You take into account that this has just been introductory. The rest of the issues are covered in other videos related to this one. Safe to say that we looked at the fact, as an introduction, that the South African system incorporates international law into its system. Then we went on to look at what international law is, the history of international law, its nature, as well as how it is incorporated into the domestic legal system, having of course taken into account the principles of dualism and monism. Thank you very much for being part of this discussion.